Okay, good afternoon. I would like to address several matters in Dr. Batten's articles. And I think most or some of the points that the ICS addresses and that you address in your articles are matters that are currently addressed by the private international arbitration institutions. For example, if you look at the attempt to make the proceedings more efficient, then the ICC president Alexei Moria announced, I think it was 3 months ago, that he will institute penalties on arbitrators who work slow. And the private market and the private international arbitration market is addressing those matters. It takes time, but they are being addressed on a day-to-day basis. And I assume that as in the same manner that special arbitration rules were put in force in the ICC, in the Stockholm Chamber of Commerce, in the LCIA, then you will see those rules, those new initiatives go around and will probably get to ICSID at some point. So on the one hand, I understand the importance of tackling those issues, but from my understanding and from my perspective, there is no need to deviate from the current system in order to tackle those. I think it's the same as with diversity matters. There is now a large private international arbitration initiative called the Pledge, which addresses specifically the matter of diversity and is now being endorsed by the LCIA, the SEC, the ICC, and all the major arbitration institutions. Well, I think that the main issue is that although BITS and NISDS is part of public international law, it is also part of arbitration law. And as part of arbitration law, it allows the parties to create and mold the right arbitration agreement and the right arbitration procedure that they want to eventually put in place. And moving on to the second article of Professor Hafto, this is exactly the point. And what I mean by that is that when I read the draft that was circulated, I read the first 2 pages and I thought, I finally found one empirical study that shows there is a backlash against ISDS. And then you continue reading through the findings and you see it's exactly the other way around. And I was kind of puzzled and tried to explain to myself how could that be. And I think that Professor Reich's words are exactly the point. It's about 2 things. It's about the countries as an importer versus exporter of investments. And the second thing is something that you would attribute to arbitration agreement, which is bargaining power. If I'm Germany and I'm now negotiating a bit with Ethiopia, there's no way that an Ethiopian investor would come into Germany and invest here. So I have no problem in pushing as much as I can to have as wide as you can ISDS procedure. And I think that the interesting phenomena of South America, of the Americas, South America and Canada, shows another interesting point in negotiations of agreements in general. If you ever negotiate an agreement, each party to the negotiations has some red lines. These red lines can be real, can be perceived, can be something psychological red lines. And I think that because of what happened with the Argentine collapse and following amounts of arbitrations that was initiated against Argentine, is that South American countries said, I'm not going to tolerate that anymore. And that's going to be my red line. So I will allow you, if I'm now renegotiating with the United States or with Germany or with the EU, I would allow myself to go to the full 10 yards with on any other subject except ISDS. And I'm not sure that the so-called backlash and the so-called public policy concerns about ISDS are actually that problematic. There are problems in ISDS, that's for sure. The main one is indeed the fragmentation of the system and the fact that there is no one institute to state the law and make the case law. But this is a relatively new body of law. It exists as a major body of law for the past 20, 25 years. If you look at the common law, it took hundreds of years to develop. And we're talking about 20 years after we started seeing the first cases coming in, the modern era cases. So I'm not sure that even the fragmentation, looking at it from a long-term perspective, from a macro perspective, is that problematic. Because in recent years, in ICSID decisions, you see panels discussing past case law and adjudicating the cases according to past case law. And it's still not precedents or binding precedents, but they do try to create a body of law. And most interesting now is that they're now introducing proportionality into ICSID decisions. And proportionality is not part of the ICSID system, has never been part of the ICSID system. The bits do not include proportionality balancing, or at least most of them don't. And yet, arbitrators and tribunals introduce them, maybe borrowing them from WTO dispute resolution mechanisms, but they are using them these days, and it's a growing trend. So I think, generally speaking, I think ICSID arbitration is now in a good place, but it needs room to grow. It needs room to develop. And I think that the ICS proposal goes counter to those efforts and to those attempts to create a genuine, real body of law that will be able to flourish. I think this is pretty much it.
No, okay.